SJC-11671, Commonwealth versus Brown.
Good morning, Ms. Strassfeld.
Good morning. May it please the court. Gail Strassfeld representing Marquise Brown. Due process and basic principles of fairness required the jury to be prompted to consider the defendant's youth and the characteristics of a juvenile brain when the jury was considering the malice, premeditation, and extreme atrocity.
No expert evidence was offered.
That's correct, Your Honor. And I don't think expert evidence has to be offered. There's a scientific consensus that the juvenile brain is different from the brain of an adult.
Haven't we addressed this already?
I assume
It was
your
different.
judge is referring to Okoro. I think in Okoro, what the court said was there's not, you cannot make an argument that a juvenile brain is unable to formulate intent or malice or premeditation. That's not what I'm arguing.
No, you're saying it's a factor just like mental impairment or alcohol consumption or something like that.
That's correct, Your Honor. And you don't need expert evidence. In the Supreme Court, when the Supreme Court decided Miller versus Alabama, it basically said, that children are constitutionally different for purposes of sentencing from adults. And it reached that because there was a scientific consensus that the brains of juveniles are different. And because the brains of juveniles are different, that leads to certain hallmark features of a juvenile, such as immaturity, such as impetuosity, such as not attending to risks and circumstances.
So here, in defense counsel's request for jury instructions, what was the request?
Well, there were several. There was one basic one just talking about putting it in the category of mental impairment. But then within
What do you mean by that? I'm sorry.
There was a basic instruction that described mental impairment and used youth as
a form of mental.
it. And I understand in Okoro that this court said very clearly that it did not consider a juvenile to be, being a juvenile was a disorder, I assume a mental disorder. But I think in Okoro, this court also took into account and recognized that the juvenile, being a juvenile, is relevant to the state of mind of the defendant and relevant on the malice, relevant on premeditation, and relevant on extreme atrocity.
But so because he's 17, he did not have an intent to kill? Because he's 17, he did not premeditate?
No, Your Honor, that's not what I'm saying.
So what are you saying?
I'm saying that because he's 17, the jury should be told in an instruction that youth are different. I don't have the exact words of the instruction, and that their brains, their characteristics of their brains are different from adults. Please consider that. You may consider that in your deliberation on the element of malice, on the element of premeditation, on the element was the killing done with extreme atrocity or cruelty.
But with regard to intoxication, we say that's required only when there's debilitating intoxication.
Correct, Your Honor.
So,
But the science on the science on juveniles is applicable to all juveniles. That's what happens in Miller versus Alabama. They take the scientific consensus and they say, we're going to apply this to all juvenile homicide offenders, just like this court did in Dychenko and in Brown. And we're going to apply that to, okay? So that's basically what I'm asking the court to do as a matter. And
Not that the jury has to pay any attention to it. They just have to be told that it's a factor.
Thank you.
but what's the jury supposed to do with that?
Well, they're
Think
supposed
about
to think
how it
about
weighs on intent.
Because you're a kid, you may find that he did not have an intent to kill.
No, Your
based
Honor.
without any psychiatric testimony about the human brain?
Well, Your Honor.
Because everybody knows 17-year-olds? Because, I mean, I'm trying to figure out what you're supposed to do.
Well, are you asking me for the words of the instruction or
I'm
how
asking-
the jury should consider it?
Well, both. I mean, I don't know what
I
precisely
think
the
the
jury
jury should-
was being asked to do here, and I mean, it's a funny thing to ask a jury to consider. Because he's a kid, you may find that he may not have had an intent to kill, or that may not have premeditated the murder.
Well, I think, well, I'll answer it a couple of ways. One, I think using the scientific consensus about juvenile brains is comparable to what the court did in Gomes when it took the scientific consensus about eyewitness identification and developed a series of instructions because it found that there was a general consensus as to certain principles. The defendants who want to use those instructions are not required to present evidence every time
Are you
about that.
suggesting then that as in eyewitness instructions, there should be something science has established that youth, blah, 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 until they reach a certain age, have impulsivity or all the characteristics that are assigned to youth, which could be a factor when in these cases? Something like that?
Well, I think that even
They need to have something, so
well, but I think
which we give them in IDs, right?
That's correct, Your Honor. It could be that. It could be as simple as directing the jury's attention to the fact that this is a juvenile.
But in Diachenko and those other cases, they're rooted in the Eighth Amendment.
That's correct.
They're rooted in. It's just not fair to treat somebody, to sentence somebody who has not fully matured. How do you transfer that to a due process
Okay.
concept? Or
Because the basis of those cases is the science. So if the science is applicable to the Eighth Amendment, I don't see why the science is not applicable to the 14th Amendment.
But how does it? How do you use it? How does it affect the decision to kill?
Well, when the jury is considering,
where the question is, was there a decision to kill?
well, if I look at the element of premeditation, you could see how if the jury has to consider the age of the defendant, focus on the fact that the defendant is a youth, they may not find beyond a reasonable doubt that that person was able to deliberate. Or if you look at, for example,
But that's we're taking the ability to make good judgment decisions, and you're sort of engrafting that on the ability to make a specific type of decision.
correct. But the science
The fact
is
that it's
but-
bad judgment, the fact that the decision was made based on poor judgment doesn't mean that the decision wasn't made.
That's correct. I'm not arguing that it's a absolute end to the question of whether the Commonwealth meets its burden on any of those elements. I'm just arguing.
In the case of mental illness or intoxication, don't we say that those things may be considered with respect to the defendant's ability to form the intent to kill?
Right.
But they're not necessarily, you can use the defendant's mental status in those situations, not necessarily to completely negate the element of malice. You could use it to, in its consideration, whether it's proved beyond a reasonable doubt that
Deliberate premeditation.
right,
for example.
or the intent to kill, or whether the killing was done with extreme atrocity or
Well,
cruelty.
you would need, for that, you'd need the intent to kill
Right.
or.
Well, or if you look at the third prong of malice that's in the extreme atrocity instruction, whether this person, knowing what this person did and what the reasonable youth, what the reasonable person in that circumstances would know about the results of the acts.
Now, you mentioned Gomes. In Gomes, we said the judge did not err because the defense counsel did not offer any evidence of the consensus opinion, so the judge could not have said to be have evidence before him or her that would require the instruction. Why are you not in the same boat?
Because the defense counsel referred to Miller versus Alabama, and in Miller versus Alabama, the Supreme Court relies on the brain science, and
But I
it's
thought
extensive.
I thought in Gomes, below, the lawyer relied on the New Jersey Supreme Court.
Yes.
How is that
Made
different?
reference to Henderson.
No, but.
Well, I
but-
think that I think that it's different because
Well,
I don't know what the New Jersey, I don't know what the New
They had
Jersey's
just done an enormous study.
of it. Yes. Well, I think that's what the Supreme Court did.
Right.
So
So
you're
I-
saying, I think, well,
Well,
but
I
you're
think it
saying
should
we're a
be
step beyond Gomes, I think is what you're saying. I mean, we're a step beyond where the defendant was in Gomes. I think that's what your
But
argument
because
is.
if you look at the Supreme Court cases from 2005 of Roper and Graham, so that scientific consensus was building over that time, and it is taking that as fact. It is taking that as this is what the science says.
Yeah, but the science doesn't say, the science that you're talking about doesn't seem to be saying that he doesn't have the ability to make the specific intellectual decisions that we're talking about. The science seemed to be saying it's a question of poor judgment.
Well,
Not that they weren't made.
I don't think so. I think the science says that the brain is not developed the same way as an adult's brain, and that it continues to develop. And because of that,
They make rash decisions.
well,
or-
not only that, they're immature, right? And they're impetuous. Yes.
But, not
but
that they-
that's part of their
but not that they
brain.
didn't have the ability to make those decisions.
Maybe in a particular instance, not generally. Yes, Your Honor, not generally. But nonetheless, what the court does is it takes that consensus and applies it to everybody who's a juvenile homicide offender. I realize that's in sentencing, and I realize that's not the same thing.
Yeah, I mean, we seem to be talking about not so much that a decision to kill wasn't made; it was made with bad judgment. It was made.
Well, no,
it
no,
was,
no, Your
It was
Honor.
immaturely made,
No,
but it was nevertheless made.
No, I would disagree with that. I would say that if you're considering a juvenile and what a juvenile's brain is formed or not formed, that the jury should consider that in deciding whether there was deliberate premeditation.
If I can turn, on page 33 of your brief, you say that during the interview on June 21, the question was asked, did the interview end at that time? Police officer, yes. He stated, that's it, I'm done, I'm not talking to anyone. Was there any objection to that?
No, Your Honor.
And with regard to the other interview, to the June 23rd interview, was there any evidence as to how that discussion ended?
The June 23rd interview ended, let me just see.
Did he invoke
Similarly,
did he
that
invoke his
Mr.
right to
Brown,
silence then, too?
Mr. Brown also similarly refused to continue talking to the police.
Is that what the officer testified to? That Mr. Brown refused to continue talking
No,
to the police? No, I'm just asking. I didn't mean to sound accusatory. What did the officer say about how it ended?
I'd have to check on that, Your Honor. I know that Mr. Brown was responding to the officer's accusations that other people saw them in the park and that they knew he was in the park. And he started to say, well, where are those people? I want to see those people. Let me talk to, let me see those people. And then the officers left the room, and then they came back and they arrested him. But I'm not addressing your question, Your Honor, of what exactly Mr. Brown said at that point, other than I want to talk, I want to see those people, I want to talk to those people.
Right. And the question really is, was there an invocation of silence with regard to that interview, as there was apparently with regard to the earlier interview, June 21? But I guess you don't know.
Well,
so
well,
it's we'll have to go back and look at the record. So,
are there more questions on that argument about the juvenile, the instruction of juvenile? I would like to, related to that, is the instruction that the judge gave right on the heels of the humane practice instruction, which told the jury to, essentially said that the interested adult rule is not applicable.
Which is true.
Absolutely, and that was the law at the time, but the instruction was totally unnecessary. The defense had never argued that there was such a rule. The defense merely brought up on cross-examination that the mom was not allowed to be in the interrogation room. And that was perfectly legitimate to bring out in cross-examination. The whole idea of the question of the voluntariness of the defendant's statement to the police is based on the totality of the circumstances.
And that's what the judge told the jury, that
But-
they were to consider the totality of the circumstances.
That's correct, but right after that, the judge says, don't pay attention to whether he's a youth. And I think the reality of...
What she said, or she just stated what the law was at the time?
You're right. She stated what the law was at the time, but that steers the jury away from considering his being 17 years old.
But wasn't she basically just saying he didn't have a right to it rather than anything else? And that was true. He didn't have a right to it. That doesn't mean that they couldn't take it into account.
Well, I think when you hear from the judge that, you know, a 17-year-old doesn't get a chance, there's no law that says a 17-year-old has to talk to his mom in the interrogation room, and there's no law that the mom has to be there with him. I think that's letting the jury know that his youth is not a consideration, may not be a legitimate consideration when you're looking at the totality of circumstances.
But that was argued to the jury.
What was argued to the jury was that he was, whether the defense argued that his youth...
Did defense counsel argue that point to the jury?
He argued that he argued to the jury in closing.
That the defendant asked to have his mother present and the police denied him the request?
No, I don't think so.
Okay.
I may be wrong, Your Honor.
It came up in, I think you said in, was it cross-examination?
Yeah, he brought out in cross-examination of the two officers before they took away Mr. Brown to be interrogated.
But he didn't argue the point to the jury?
No, he did argue youth to the jury. I thought that's what you were saying, Judge. No, he did argue youth in the closing argument to the jury to explain why he might not have been forthcoming with the police at the first, at the time. And I'd also like to...
was there an objection, by the way, to the reference to the parent during the course of the instructions?
No, Your Honor.
So we're in the world of a substantial likelihood of miscarriage of justice.
That's right, Your Honor. There was an objection to the instructions on youth. And
right.
Yes.
Was there any objection to the question at the cross-examination question, by the Commonwealth to the cross-examination question?
No, Your Honor. I don't believe so. I can be corrected. I would just like to briefly address the Commonwealth 16L letter that was submitted, and its citation to Commonwealth versus Kayot. I want to point out one critical difference between this case and the case in Kayot. In this case, the trial judge specifically admitted the co-defendant's statement under the joint venture exception to the hearsay rules. There's no question that's what the judge did. And impliedly, when the judge does that, she was rejecting the Commonwealth's claim that it's only coming in for its falsity. But more than that, the judge never gave an instruction to the jury.
But the defendant waived the instruction.
No,
didn't the judge offer a limiting instruction?
Well, the judge was going to offer an instruction about joint venture, which she eventually did. But that's different. When a statement comes in under joint venture exception, once the jury finds there's a joint venture, it's in there for anything.
But okay, accepting what you say. In point of fact, though, the statements that you're talking about, which is Gonzalez saying, you know, we went to the Chinese restaurant and then the Commonwealth, it may have come in as a joint venture statement, but there's nothing inculpatory about it. It's all, is there? I mean, in other words, they're, whatever they might have said, their point at trial was, this is all a lie.
Well, two things. One, the whole statement was not, there was definitely truth in some of the statement. There's video showing them at the restaurant. But putting that aside, we don't know what the jury made of it, because the jury could do anything with it. And the Supreme Court has told us, if you're going to put it in for falsity, you have to put an instruction to the jury that's only falsity. But
Or didn't the closing arguments also clarify that Gonzalez's statements weren't presented to prove the truth of their contents? I thought in the closings it was clarified. In any event. Well.
No. I don't know of an instruction like that.
It's, at least from what you say, it's very clear the judge allowed it in as a joint venture.
A joint venture, and there was never any limiting instruction.
No, I know, but I'm saying that in the closings, didn't the counsel make clear that it wasn't being admitted for the truth, but to show that they were lies?
Well, I mean, the Commonwealth?
Yeah.
Yeah, well, but we don't know what the jury did with it.
No, but I mean, but how would it?
It was
even
never
if the
to be
jury
true.
didn't.
Well, one other way is the defense was that Mr. Brown's defense was that he was an innocent bystander, and that it was Gonzalez, right? So if you bring in this statement that shows that their statements are the same and that they're false, it's making him appear to be tied in with him. And works against his defense.
But
so that's how it's harmful, even if you think it's just for its falsity.
But if it had come in for its falsity with a limiting instruction, wouldn't just what you just said be true, just the same?
But it didn't. And I'm saying that under the Sixth Amendment, it's very clear under Street and under Crawford, it's very clear that if you're going to bring in a co-defendant's extrajudicial statement, that without a limiting instruction, that's a violation of the Sixth Amendment.
All right, thank you.
Thank you.
Good morning. May it please the court, Jamie Michael Charles, Assistant District Attorney for Middlesex on behalf of the Commonwealth. If your honors will permit, I'll pick up where my sister left off, which is just to briefly address the confrontation clause question. I do think the Kylot case, and I hope I'm pronouncing that correctly, that the Commonwealth submitted or referred this court to in its 16L letter is the perfect case to refer to in assessing this question.
Okay, but Mr. Charles, do you acknowledge that, in fact, the judge and the Commonwealth at trial did not seek to have it in for falsity, but it was as a joint venture?
Well, a couple of points. It certainly was admitted at trial as a joint venture statement, substantively. There was no limiting instruction that it could not be considered for its truth. That being said, the Commonwealth's arguments during sidebar, and even the judge's recognition, I would say, it's, I believe, volume 7 at page 10, the judge recognizes that this statement is not being offered for its truth. There's no possible circumstance where the jury could have been confused as to whether the statement was being offered for its truth. It was simply offered to show that it was made so that the Commonwealth could subsequently show, through testimony of Paul Jurgen and Chris O'Shea, through the surveillance footage showing the car, through the defendant's admissions in his jail calls, that this was a false statement. That is exactly what the Commonwealth argued in closing, transcript 9, page 41.
But your sister's saying, I take it, that without a limiting instruction, there's no way of knowing what the jury did with it, and they could have considered it substantively.
And it is that point that I was trying to make at the outset, which is my sister mischaracterizes Kylot. I'll read to you from that case, which Justice Gants authored here. Here, Santos' statements to police on the evening of the victim's murder were admitted without limitation. The judge did not instruct the jury to consider this evidence only against Santos or advise them that it was not to be considered for the truth of the matter asserted. That instruction was absent in Kylot as well, but this court said nonetheless, where it was clear that the statement was offered not for the truth of the matter asserted, but simply to show that it was made so that it could be subsequently shown to be false through separate admissible evidence, that is not a Confrontation Clause problem.
Let me ask you, how does it hurt the defendant if the statement is taken by the jury for its truth?
It couldn't hurt the defendant. This case is actually stronger than Kayat because in that case, the court said the only person who would want anyone to believe the statement was true was the defendant. Here, the defendant wants the jury to believe it's false as well because the defendant's theory is Gonzalez was there and Gonzalez shot the victim.
Well,
I'm sorry?
Isn't the statement about what they did afterwards?
The statement was an alibi statement as to where
Why would the
Gonzalez was on the afternoon that the victim was murdered. Gonzalez says to the police, and mind you, this is a statement, just to give the court some context, this is a statement that was made before the police even knew who Gonzalez was. They show up to Brown's house at Countryside Village Apartments, the defendant's house, while they're canvassing. They have some reason to want to interview the defendant because the defendant had an altercation with the victim the night before. Gonzalez happens to be on the couch. The testimony of the officers is, we didn't know who this guy was, but we asked him, where were you the other night? And he provides the statement. Well, I went to this party, but I went home early to my hotel. Then I went to the Chinese buffet the next day. I left around 12:30 to go to work. That's his statement. That's it. That's all the Commonwealth put in from Gonzalez. And again, it was only offered because Marquise Brown gave a similar statement. He said, I went to the Chinese buffet, and this was all corroborated by a third-party witness, Maria Reyes, who testified.
So why, I thought the defense, wasn't the defense that Brown was there, but
Well, that was the defense at trial, but
Yeah.
earlier on, the defendant had maintained that he wasn't there in multiple police
okay, but we're talking about
interviews,
trial. We're
in
talking
jail
about
calls with his-
trial. I mean, that's
This
where it
evidence
matters.
came in at trial. This evidence was introduced to show, and the Commonwealth charged Mr. Brown with acting as a joint venturer.
Right, I guess I'm just trying to get it. You said that the defendant would want the jury to think that what he said was false, and I'm asking why is that so? Because what he said about what he was doing at this time was the same as what the defendant said he was doing. They went to the restaurant together, didn't they?
No, the fact that they went to the restaurant together is not the relevant portion of the statement. The relevant portion of the statement is what they did after leaving the restaurant. And that testimony was the defendant was dropped off at Countryside Village. He stayed there for the rest of the afternoon. Gonzalez was not there, was apart from the defendant, and went to work all afternoon. Those are the aspects of the statement that are relevant and that constitute the alibi defense, because that's where they were during the relevant period of the murder. Okay. And if the defendant's position at trial was Gonzalez was there, Gonzalez pulled the trigger, then he is equally interested in the jury discrediting Gonzalez's statement that he was at work all afternoon.
Got it.
That is the point the
Now,
Commonwealth is trying to make.
in opening statement, I haven't read it, but I assume the Commonwealth said Gonzalez and the defendant go into the park and the defendant shoots him.
Yes, and the Commonwealth's position is that Gonzalez was acting as a lookout, and that the fact that his bandana was found halfway down the trail supports the conclusion that he was standing there at the time the defendant was further down the trail shooting the victim, and that they then both fled back to Gonzalez's station wagon and left the scene together.
And the defendant in his opening says anything about his theory of the case?
Well,
do you remember?
I do not have a specific recollection of the opening statement. Certainly his closing emphasized repeatedly that he was there, but that Gonzalez was the shooter, and that he had no idea that Gonzalez was planning to shoot the victim.
So both at some point are arguing to the jury that Gonzalez was not at the Gulf Station at work, but he was with the defendant.
I don't believe anyone at any point in trial ever suggested that Gonzalez actually was at the Gulf Station.
Was Gonzalez charged as well?
Mr. Gonzalez pled guilty, I believe, to second degree.
It was voluntary manslaughter.
Or voluntary
But didn't he get
manslaughter,
8
if
to
I'm
12 or
mistaken.
something like that?
He did not. He was charged. He did not go to trial. He accepted a plea bargain offer.
And the only evidence, there was no evidence as to what occurred at the actual shooting.
No.
It's all by inference.
That's correct. There was
the location of
an
the
abundance of
bandanas.
evidence that they were there during the relevant time frame, and that Mr. Brown had a pretty concrete motive for wanting to kill the victim, Tyree Lewis. But there was no evidence of what actually transpired, other than inferences to be drawn from the forensic evidence, the testimony of the medical examiner. If there are no further questions with regards to this, Mr. Gonzalez's statement, I'll turn to the absence of an instruction on youth, which my sister spent a large portion of her argument discussing. It's interesting, the Commonwealth and the defendant aren't actually that far apart here. The only difference in the Commonwealth's position is that there should be some evidence in the record to support the issuance of an instruction. The Commonwealth views this sort of instruction that the defendant is requesting as the equivalent of essentially a mental impairment instruction, and we require that there be some record evidence to support that instruction in order for it to be given. Justice Botsford, in Okoro, I believe it was footnote 23, this court essentially says, and I don't want to misquote it, the mere fact that the defendant was 15 years old when the events occurred cannot be the basis in and of itself for a finding that the defendant lacked the necessary mental intent to commit the crime.
Right, but the argument, Ms. Strassfeld's right, the argument that was made, at least on appeal there, was that the jury should have been told that it would eliminate intent.
I completely understand, and the Commonwealth accepts that that is what the opinion focused on. But I think what you can divine from that is just the fact that you are a juvenile, absent any other evidence about juvenile brain development, how that impacts any cognitive functioning, not even necessarily expert testimony, but even any lay testimony about common sense understanding. Absent any of that evidence, and there was none here, expert or otherwise, the defendant cannot suggest that he is entitled simply because he is a youth, or excuse me, a juvenile, to such an instruction, particularly where, as Justice Spina was identifying, there's not a direct correlation. If you look to Miller and the cases that talk about this, accepting that this is obviously an Eighth Amendment issue in Miller and Duchenko, when they talk about these common sense factors that we understand juveniles to experience, transient rashness, proclivity for risk, inability to assess consequences, these are talked about in the sense of their assessing their moral culpability. And that's why the court talks about, and why the Supreme Court and this court subsequently ultimately ruled that there is an altered sentencing structure for juveniles. We recognize that there is a greater possibility for rehabilitation and that there may have been a lack of reasoned judgment in the commission of the crime, and for that reason, juveniles who are convicted of first-degree murder are not sentenced to life without the possibility of parole. This defendant had the benefit of that decision and actually came up before this court and had his sentence restructured to life in prison with possibility of parole after 15 years. And that is the benefit that you receive based on this science that people, that everyone understands.
The point, is your point that the accepted science sort of goes to, at least to date, goes to moral capacity?
That would be the Commonwealth's position, and I think that's borne out in the language of Miller.
But I think you're also saying that that isn't to say that it may be that youth in general, not just Mr. Brown, but youth in general, have some psychologist might testify, have difficulty. I mean, they're just different than adults in terms of being able to form intent. Is that what you're saying? Or are you just saying that you would need, I guess what I'm trying to get at is this. You said we're not that far apart. Are you saying that somebody could testify about youth in general, not saying they can't, but that they sort of being able to have a deliberate premeditation is just different? Or are you saying it would have to be evidence with respect to this defendant himself?
I think I'm testifying, or I'm not testifying, I think what the Commonwealth is saying is that exactly what happened in Okoro could have happened here. There could have been testimony that does need to be directly linked in some way to the events that occurred in the case. But my understanding of the expert testimony in Okoro was that it generally related some principles about juvenile brain development and perhaps some shortcomings that juveniles may experience that adults don't experience, and related that to the defendant's actions in that case on the evening of the murder.
Right, I think...
And that is the kind of testimony that the Commonwealth is suggesting the defendant can present in any case, and at that point be entitled to essentially a mental impairment instruction. The jury may consider, among other things, the defendant's age in considering whether he had the ability on the night in question to form the knowledge or intent necessary for murder.
Yeah,
but absent any evidence in the record whatsoever to suggest that you're just entitled to this instruction because you're a juvenile flies in the face of the legislature's pronouncement that you are to be tried as an adult, and this court's pronouncement that juveniles can form the intent and knowledge necessary for murder. So you don't get the instruction just by virtue of being a juvenile. You have to put some evidence into the record, informing the jury why that would be the case. I think the point was well made by numerous justices when my sister was up here. How is the jury supposed to understand how this concept of age plays into it? Certainly people's understanding of age and development doesn't extend to the point that they can understand the brain science behind it. We certainly can't suggest that the average juror understands that. And absent any evidence of those facts for the juror to understand the context in which this could affect knowledge or intent or deliberate premeditation, it's inappropriate to give that instruction. It's irresponsible to give that instruction. If there are no further questions on that issue, just by extension, I'll briefly move to the instruction on the interested adult rule.
Okay, before you get there.
Sure.
I'm done, I'm not talking to anyone. Is that not invocation of silence?
Just to clarify, yes, that is. And that actually was how the June 23rd interview, not the 21st interview, concluded. So that was the conclusion of the June 23rd interview.
That was the Miranda. That was the arguably the custodial one, or the one that's more
correct. And
more arguably custodial.
Correct. The June 21st interview was an hour long and ended amicably, and the defendant went home.
But why did the jury hear that?
The Commonwealth is not suggesting that the jury should necessarily have heard all of. I will admit, it was very limited. It's 3 pages of transcript, and this is testimony of officers in response to sort of an open-ended question from the trial prosecutor. I'm not suggesting the jury should have heard that the defendant terminated the interview at that point.
I mean, they could have heard the officer could have said he terminated the interview. That's it. It's the quotes. It's the quotes that I'm wondering about. The actual invocation.
Sure. I think the Commonwealth's larger position, regardless of whether this court considers the admission of that particular quote to be error, is that under no circumstances does that come close to rising to the level of a substantial risk of a miscarriage of justice. This second interview.
Likelihood.
I'm sorry?
Or likelihood.
Oh, substantial likelihood. My apologies. The second interview, which was quite brief, essentially involved the defendant reiterating the same alibi defense that he had proffered during the first interview, which was properly admitted. It was no surprise to the jury that the defendant was a liar. So I would dispute my sister's characterization in her brief that this would have caused the jury to believe that he was a liar instead of believing that there was some innocent misrecollection. The jury had numerous statements from the defendant's own mouth, from eyewitness testimony, that the defendant lied when he said he wasn't there. And that was the crux of his statements during these 2 interviews, was I was at home. I was not at Callahan State Park. Those representations are belied by his subsequent admissions during the jail calls. They're belied by the testimony of Paul Juergen and Chris O'Shea. I believe during Paul Juergen's testimony, an article that he saw in the newspaper was admitted with a picture of Mr. Brown as the individual, and Mr. Juergen essentially testified to the effect that that's the guy I saw at the park. The defendant's statements, spontaneous utterances that he makes moments after he's arrested to the effect of, how can I be charged with murder when you don't have a firearm? He had not been informed at that point that there was a murder investigation involving a firearm, so he had exhibited knowledge of the means of the murder that had not been conveyed to him. So that belied his statement that he wasn't there. So to the extent that this was error, it certainly did not rise to a substantial likelihood of a miscarriage of justice. If there are no additional questions, I'll just return.
With regard to the questioning that was admitted from the police officers, was there any objection to that? Was there any?
No. There was no contemporaneous objection to
and was it all redacted? Was there any redaction done of? I guess it was. I guess
it
no
was not
tape
recorded
recording.
at the defendant's
There was
request.
no tape recording,
both interviews. So there was no record of the interviews. This was all just testimony from the officers at trial.
And there was no objection to any of that coming in.
No. I mean, there was certainly a motion to suppress prior to trial, but at trial, no objections.
And the motion to suppress, I gather, did not make reference to limiting the extent of the police questioning coming in.
No, it did not. And that the decision in the motion to suppress is in my sister's record appendix. Briefly, with regard to the instruction as to the interested adult rule, as this court knows, that rule obviously is not applicable. And all the judge instructed the jury, and this is at volume 9, page 68, is keep in mind that the police are under no legal obligation to give people 17 years of age or older an opportunity to have a parent accompany him or her in a police interview. That's the only instruction they received. And I would dispute my sister's representation that that did not come up during cross. There was cross-examination of 3 separate witnesses, Detective Hendry, Trooper Baker, and Detective Crawford, all repeatedly asked about why they didn't allow the defendant to consult with his mother or have a reasonable consultation with his mother, or why she wasn't allowed to come into the room. In particular, at transcript volume 8, page 163, I'd like to read to you a little exchange. Defense counsel, did you ever ask him if he wanted to have a parent present during the conversation? At his age, he did not require it by the law to have a parent present. So you're referring to the law that requires that someone who's 16 up to the day before their 17th birthday, somebody who's younger than 17, the law requires that they have a parent present, right? That's what the law requires. But he's just 17 years old. Don't you think that maybe it would be incumbent or helpful to have a parent present? So there was this interaction between defense counsel and one of the officers where there was certainly the possibility for confusion among the jurors about whether or not there actually should have been consultation legally with his mother. And the Commonwealth, later on, volume 8, page 183, raises that point. They say the defense attorney has been talking to has been crossing numerous witnesses about the presence of the mother. We feel that there's a potential for confusion. We would request that this correct statement of the law be given in conjunction with the voluntariness instruction. And the judge agrees, and I would argue that a reading of that exchange does not suggest that the defense counsel actually objects to that at that point. He says, well, the officer testified to it, but he doesn't object when the judge says, I understand that, but I'm still going to give it. I'm trying to see. I guess if there are no further questions on the other issues, the Commonwealth would be content to rest on its brief and ask that you affirm the defendant's convictions.
All right, thank you.